Hello, my name is Barry Stanton. I'm the managing partner at Boyce Turner, and I've also practiced as an employment lawyer for the past 25 years. In that time, I have seen the growing importance of a knowledge of European and international employment law. In this series, I am talking to my European colleagues with whom I have worked on numerous projects about 5 things we should know about employment law in their country. Today, I'm joined by Matthijs Roos-Krolios, who is a partner at the Dutch law firm of Doorn and Keizer. Matthijs, hello.
Hello, Barry.
So I wanted to explore a few issues with you around termination, and particularly around redundancy and how that's treated in the Netherlands.
Yeah, well, in the Netherlands, the termination there is a limited amount of grounds for termination. So termination, for example, with regards to economic grounds and incapacity for work is dealt in one way, and the other grounds are dealt in another way. And so I think first start with the economic grounds. You can't terminate in the Netherlands without permission of the UWV, which is a government body. And you have to first prove that there are economic grounds to terminate the employment agreement.
And how challenging is that to prove?
Well, it depends. There are a couple of reasons, like economic reasons, for example, financial reasons or changes in the organization, etc. For financial reasons, you have to show why. So you have to show all the annual accounts. For changes in the organization, you have to show that with big spreadsheets and how the roles change, etc. And after you send this in to the UWV, the employee or the employees can defend themselves and state that it's not right or anything. So it can take a long time, at least 8 weeks.
At least 8 weeks. Okay. Can you act more quickly than that for economic grounds, or is that really it?
You can always try to come to a mutual agreement.
Right.
It's not always that easy. However, you always still, after that 8 weeks, you still have to take into account the notice period. You can deduct the period of this process, but there always will stay 1 month of notice period will be applicable.
Is there a typical notice or a statutory notice period?
The statutory notice period in the Netherlands is 1 month for the employee, and for the first 5 years, it's 1 month for the employer, and then every 5 years, 1 month extra.
And is there a maximum?
Maximum is 4 months, yes.
4 months, okay.
Or you can differentiate from that, and then it's always the employee has at least the half of the employer's notice period, with a maximum of 6 months for the employee, so a year for the employer. For example, we don't have golden parachutes in the Netherlands, but with a statutory director, you take up something like that at least, and he has something of a golden parachute in a contract.
That's the economic grounds. And then looking at the other grounds?
The other grounds are, for example, inadequate performance, culpable conduct, etc. But in that case, you have to go to court and ask the court to terminate the employment agreement.
And would the employee be aware of you going to court?
The employee will definitely be aware that you go to court, because he can defend himself as well. And especially with what is the most ground which is normally used is inadequate performance. But before that, you have to have a PIP, so personal improvement plan.
And how long would the PIP normally take in the Netherlands?
We always say 3 to 6 months, but if a court is generous, they will award a 3 months PIP. It's enough, but normally they would ask for 6. But the most fun is that if you look at the case law in the Netherlands, mostly you never see case law based on adequate performance, because if there is a correct PIP, they will settle after that.
In the UK, one would expect to have, a meeting and tell the employee what you expect them to achieve, and they get a reasonable period of time, so a month. And then you have another meeting. Is that the similar process in the Netherlands?
Yes. You get your PIP for 3 months or for 4 months or etc. We always start with 4. And then you have every week at least a meeting with one of your coaches. And then halfway you have a check-in to see how it's going. And at the end, you have the final meeting.
Presumably during that PIP with the coaches, you're supposed to support and help them get to the level they're supposed to get to?
Yes, and even if necessary, give them a training or etc.
Most employers be familiar with that.
Most English clients we have, they know how it works.
Do employers try and avoid that and reach a mutual agreement, or are they quite keen to go down that route?
I would say, at least in our clients, that at least foreign clients don't know how the Dutch court works. So they would always try to come to a mutual agreement.
Right. Okay. And you and I have talked about people going sick and having to be very careful about how you treat people or what you tell them. Can we just talk a bit about the rules around sickness and termination?
Yeah, we always have, at least from HR managers, they always say we come and live in the Netherlands, because during sickness in the Netherlands, the company has to pay the first 2 years of sickness, the salary. So normally it's, in law, it states it's 70% of the maximum daily wage during the first 104 weeks. So that's around, the daily wage is 5,500, nearly 6,000. So it's around 3,500 minimum per month. However, most companies pay the first 52 weeks 100% of the salary, and the second year 70% of the maximum daily wage. And during that period, you can't terminate the employment agreement.
That sounds like a lot of fun.
That's a lot of fun. And if you don't do everything right according to the company doctor, etc., so help the reintegration, the UWV, the government body, can award a third year that you have to pay the salary.
Okay, that's quite a lot of money. So how would you go about terminating an employee and to avoid having the employee going sick?
So with regards to a redundancy, you can start the procedure at the UWV without the employee knowing. And once it's filed, you will inform the employee and he can't call in sick anymore. Or if he calls in sick, then the process is already going. And you can later go to court and state, hey, he called in sick because of this. In case of a court hearing, that's a little bit more difficult because the employee already knows that there is a PIP, etc. So in that case, the only thing is make sure that he's going as quick as possible to the company doctor, because probably like the same in the UK, an employer can't ask the what's really the sickness of an employee for privacy reasons. So only the company doctor can see if the employee is really sick.
So if the company doctor then says the employee is well enough to work, does that mean that they're not then sick, even if their doctor says they are sick?
No, if the company's doctor says he's not sick, then he's not sick. The company doctor can state there is, for example, some problems on the work floor. So he advises maybe mediation or anything else. And that's something we always advise, or as only possibility to terminate the sick employee. If there's also something on the work floor, some problems, you can try to persuade a company doctor to state, maybe there's something more, so maybe mediation would be a good idea. And during mediation, everything can be on the table, and that also including termination.
Can be quite tricky.
The latest time, there's a lot of sick employees here in the Netherlands, unfortunately. I will bring you one more thing with that. There is only one reason to terminate during sickness, and that's when the company closes. Not only when a section of the company, but the whole company. But that needs to be a separate entity. And if it's, for example, a branch, we just had an English client, and they only had a branch office, and they were closing the branch office here in the Netherlands, and they had one employee who was sick. And the government states, well, then England can still pay for it during the sickness. So even if the branch is closed, England could still pay the salary.
And closing a company is quite an extreme way of getting rid of one sick employee.
Well, I think we had 5 of them in the last year trying.
That's very interesting. Thank you, Matthijs. Non-competition, restrictive covenants. I mean, that's always a very hot topic for employers. So can we just talk about the position in the Netherlands again?
Yeah, because it's currently still different than in the UK, for example. If you have a signed and legally binding non-compete, it's valid in case of termination, then the company does not have to pay during the non-compete period. However, there are a couple of rules. The employee who signs it has to be 18 at least, and there has to be a specific time during which non-compete is valid. So it will be around, normally it's between 6 and 1 year, month and 1 year, but it could also be up to 2 years.
Okay, so and how do they judge? Because I mean, there's always a lot of debate in England around the validity of a covenant, and with a maximum period of 12 years at the very top end. But if in the Netherlands you can go to 2 years, how do you judge what is reasonable? Is it judged on reasonableness, or is there some other test?
No, in principle, as stated, they don't judge it at all. If it's valid, then it's valid. However, you used to be able to make a non-compete for a definite period of time contract as well. It's still possible, but then there have to be very important business interests, which are not often there. But for an indefinite contract, it's still possible. However, an employee can, of course, go to court and try to waive the non-compete later on. We used to have one of the reasons, which is a heavier burden. So when an employee started as an intern and now is a partner, that could lead to a heavier burden. However, that's no longer that much taken into account. However, if the non-compete does not make it happen that he can find a new job, or that he got a very short employment agreement, or there are no really business interests of the company, that could lead for the company, for the court to waive the non-compete or maybe reduce it in months.
Okay, and just in terms of the breadth, so the geographical extent of a covenant, are they limited to the Netherlands, or can they extend worldwide?
They can extend worldwide. That's the whole problem. But of course, this is if non-compete is much more reduced, for example, for the Netherlands, or to a specific scope of kilometers or miles around the city, then it's more reason for the court to uphold the non-compete. However, sometimes you see it's for the whole Europe or Northern Europe, etc., and it's still in place. But be aware, in March 2024, there is a new draft bill, and that could lead that it has to be maximum 2 years or maximum 1 year, and the company has to pay. But however, this is still pending, this bill. So that would be that it look much more than to the UK, if I'm right, that the company has to pay to uphold the salary during the period of the non-compete.
No, we don't have to pay in the UK.
Oh.
But you do in places like Germany and France. There has to be some form of payment, whereas in the UK, you just need consideration at the time they sign the contract. The final point I wanted to talk about was on-call employees, which I know I think are a perennial problem in most countries. But what are the issues in the Netherlands?
It didn't used to be a problem in the Netherlands, because an on-call contract could be a 0 hours contract or a min-max contract, etc. And it used to work when the company needed some extra hands, they could call those person, etc. However, in the last 5 years, this changed, and we've got more legislation on this, and there probably will be even more legislation in 2026. That's also a draft bill, but for now, the company have to inform the employee at least 4 days in advance if they want the employee to work. And if the company during those 4 days terminate or say it's no longer necessary, they still have to pay for the period they wanted to call this employee. In a collective bargaining agreement, there can be a couple of changes, but that's not many options for change. Also, there is a minimum on-call period in place, which is at least 3 hours per day. If you call an employee, it will be at least for 3 hours. If you call the employee for 2 hours, they will be paid 3 hours. And then the most obligation, which we talked about a little, is what happens after a year. For foreign employers, it's very difficult and different. But After a year, the employee has to get a contract for the period for at least the hours he worked in the last year. So an average amount of hours.
So, I think here we're talking about 0 hours contracts and the employee being called at various points. Has that legislation meant that employers have moved away from 0 hours contracts?
Yeah, that's correct. The whole government doesn't want to have any on-call employees anymore. Seasonal work is probably the only option which is there, for which the government is allowing on-call workers.
We have a similar situation here with the Labour government, and the trade unions don't like 0 hours contracts, and employers saying, but they work very well. And for some people, they do work very well, but they get abused as well.
Yeah, we have the problem with a student who likes to be an on-call worker, and he can say yes or no if he is called. But after a year, he gets a contract which he doesn't want at all, with an average amount of hours.
And what happens in that context?
Well, he is, of course, entitled to say no. But if the company forgets to give him this contract, then it's automatically, by law, he gets this amount of hours. So if, for example, he works 15 hours a week average the last year, and the company forgets to give him this contract, within 1 month after the end of the year, the employee is entitled to 15 hours a week, if he works or not.
Do people enforce that?
I bet they do. It's free money.
For the employees, yes. Are there mechanisms to stop abuse, so to stop an employer terminating the contract just at the point where they're about to roll over and get the benefit?
There are, but if it's a definite contract, of course. If a definite contract ends by operation of law, if it's an indefinite contract, then we get back to the start again. Then there has to be one of those grounds to terminate the employment contract. And the problem is that, as we call it a closed termination system, that if you don't have the whole dysfunctional employee, but only a little, then that's not enough reason for the court to terminate.
That is problematic, isn't it?
That's definitely, yes.
I think at that point, we probably ought to leave our discussion about termination before everybody gets too many grey hairs. Matthijs, it's been wonderful talking to you. Thank you very much.
You're welcome.
Thank you for joining us today. I hope you've enjoyed our conversation. If you want to listen to more episodes in this series, you can follow or subscribe to our podcast. Goodbye.